All right, let's go on the record on cause number DC193038. Council, make your appearances.
Your Honor, is that Crapeau and Reniger versus Combs?
Yes, Crapeau versus Combs.
This is Maureen Farrell. I'm here appearing for the plaintiffs Diane Crapeau and Laurie Reniger.
Your Honor, John Galini for the defendants, Michael Combs and Combs Properties LLC.
All right, let's go ahead and proceed.
Your Honor, we're appearing here on my motion, which is a motion for partial summary judgment solely on liability with respect to breach of fiduciary duty by the defendant, Michael Combs. The arguments are fully set out in our second amended motion for partial summary judgment, and it's a modest motion. We're not asking the court to make a final determination with respect to damages, but merely to find that there is liability for a partial summary judgment on breach of fiduciary duty itself. The motion is based on the judicial admissions, which are set out in full in the motion itself, based largely on the deposition testimony and the responses to discovery by the defendants, whereby the defendant, Michael Combs, admitted that he had a fiduciary duty, and that is a particular position of trust with respect to the plaintiffs, his siblings, and that he breached that fiduciary duty by a failure to keep an accurate account of the funds and assets that he received from their mother, Betty Combs, during her life, and that he failed to disclose significant transactions and receipt of funds and expenditure of funds in relation to the funds that he received and that his companies received on her behalf, that he commingled funds with his companies, which is admitted in the deposition testimony, which is before the court and excerpted in the motion itself, and that he engaged in self-dealing. The non-movement and the defendant filed a response, but the response was insufficient to contradict or to raise a genuine issue of material fact. This court has granted a motion to compel discovery responses because we've had a really hard time getting information sufficient to create an accurate account of how the assets and the really hundreds of thousands of dollars in cash and assets have been used, what amounts were gifts, what amounts were used to help Betty Combs and the party's father, and what amounts were really for the account of Michael Combs. The response that was filed by the defendants merely recited the affirmative defenses and referred the court to the affidavits, discovery, pleadings on file without actually raising the genuine issue of material fact that would be required by the rules. That's 166AC, that this court is not required to make the non-movement's arguments for them, that they needed to really point out what genuine issue of material fact exists, which they're unable to do. Throughout this entire
I share your concern about that. I mean, the briefing by the defendant is kind of unclear. It doesn't cite to any cases, really. I mean, other than basic, summary judgment standard stuff, and doesn't really cite like what within the briefing, within the affidavits refutes the fiduciary duty. And so I definitely do share your concern about the briefing.
Thank you, Your Honor. And I think that this kind of goes hand in hand with the prior ruling of the court, which compelled additional disclosures. It's been difficult to get information, and really that just speaks to the heart of the breach of fiduciary duty, that there's been a failure to account. My clients have expended $6,000 in engaging a forensic accountant to go over all of the records to try to just ascertain like the amount of money that was received by either Michael Combs or his companies, and then the amount of money that was then re-expended to assist the parents. And so we could come up with an accurate accounting for the estate. And we've so far been unable to do that. And I think that really goes to the heart of the breach of fiduciary duty. It is unrefuted that funds were commingled between the companies and the individual. That is in itself breach of fiduciary duty. And given that the response doesn't raise a genuine issue of material fact, we ask that the court enter partial summary judgment. And and allow us to, obviously there are issues of material fact with respect to the amount of damages, right? And the amount of the actual nickels and dimes. But I think that that per se, the breach of fiduciary duty is really established as a matter of law and unrefuted by the response offered by the non-movement.
Response?
Yes, Your Honor. Good afternoon. First of all, in the response regarding the affirmative defenses, that's only if the plaintiff meets their burden in the first place. To meet the burden, obviously, the plaintiff must conclusively prove all essential elements of the claim. Counsel for the plaintiffs is brand new, and she's certainly not fully familiar with the history of discovery with the previous two different attorneys that have served on this case. Discovery has been handed over to them in a timely manner and also in a supplemental manner where there would be additional motions to compel. There is a treasure trove of information that we've had to find as a result of extending back all the way back to 2006, which did take sometimes between computers and banking records to suffice that. But we have done that, and that has been supplied to the attorneys, the previous attorneys. The present counsel has just recently, as you can see, been designated as counsel on this, and may not be aware of all the discovery yet that has been provided to them to prove all of the transactions.
Mr. Galani, let me tell you kind of what my concern is here. If you look at your briefing, for example, on page, these aren't numbered, so I'm not sure what page this is. I think it's page 5. It says, movements are entitled to summary judgment as a matter of law and allege that movements can prove the claim of breach of fiduciary duty and disprove at least one element of non-movement's affirmative defensive waiver. And I guess your response to that, I'm not sure, it says non-movement's claim a genuine issue of material fact exists as to non-movement's affirmative defensive waiver and submit an affidavit, discovery, documentary evidence, and movement's pleadings as summary judgment evidence referenced in an appendix attached hereto, filed with this response and incorporated by such reference for all purposes as so set forth verbatim herein. The concern I have is there is a number of pages of affidavit and discovery responses. Pleadings can't be considered as evidence, so I'm not going to consider that. But you don't tell me what within the affidavits or what within the discovery supports your position as to waiver. You've just cited basically everything. And so I'm not sure exactly where to go to or what your argument is or what cases you're relying on, because none of that's within your briefing.
Your Honor, as to the first aspect is that they have to prove conclusively that reasonable people could not differ as the conclusion to be drawn from the evidence that they have on their summary judgment. And we propose that they have failed to meet that standard.
I mean, Your Honor, if you refer to our, if I may, if you refer to our initial second amended motion for partial summary judgment, I cited extensively to the deposition testimony of Michael Combs and to his discovery responses. I broke that out by each element of the a breach of fiduciary duty, establishing the breach of fiduciary duty, the standard, and the breaches that we're claiming. So, we put before the court a prima facie case that there was no genuine material issue of fact with respect to the existence of a fiduciary duty. We set out the standard and we set out the breach. So, Your Honor, are you sharing this here?
Yeah, I'm sharing the screen here of
Yes.
your brief. Is that correct?
Wonderful. Yes, this is exactly right. So if you go to, it's lengthy. If you go down to paragraph here, 28, we refer to the summary judgment evidence, which is exhibited. And then in the arguments and authorities. Here at 34, we set out the elements of the claim. So first is the existence of the fiduciary duty. We refer specifically to the deposition testimony of Michael Combs. And then the duties of the fiduciary, which is with reference to the law, a duty to avoid self-dealing, bad faith, adverse acts, reckless indifference, but also negligence, right? That bad faith is not required. And then we set out through deposition testimony and the summary judgment evidence through responses to discovery that we've exhibited that there was a breach of these fiduciary duties.
Your Honor, they haven't set out whether the defendants were ever, or whether the plaintiffs were ever owed a duty. We're not discussing Betty Combs here. We're discussing the Laurie Reninger and Diane Crapo. And they have not set out in any fashion that would pass fact or law that there was a duty.
So Mr. Galini, so are you seeing the screen here? It says Combs has fiduciary duty to plaintiffs. And they say by undisputed deposition testimony by Michael Combs, he admitted that he had a fiduciary duty to the plaintiffs. And then he sets forth all of this evidence.
Those are all inferential leaps, Your Honor. There's nowhere where he's stated that he has a fiduciary duty. We're dealing with gifts, Your Honor, gifts that were provided under IRS standards. And even counsel earlier in her discussion with you, Your Honor, stated that we were dealing with gifts. And then that takes it into a whole different avenue, Your Honor, as to whether a fiduciary duty even arises from a gift. Now, Your Honor, the deposition transcript or the deposition transcript is very clear that my client felt like he owed a moral obligation. We're not parsing, but whenever you have a gift under the law.
So there's definitely case law in Texas that talks about the creation of fiduciary duty where you have a special relationship. And I guess my frustration here is that there is a lot of, the plaintiffs here or the movements here, I guess, have very clearly, I think, set forth what the claims are, what the breaches are. They've cited to particular portions of the record. They've cited to meet the law, and in the response, none of that was done. I guess the idea is that I would kind of search through and try to figure out what within your briefing and your evidence would respond to their briefing, but you don't cite anything in the record in your briefing or any law that responds to what they're saying. That's my concern here. I hate to, the Court of Appeals has said that, hey, if you don't do that, I can just grant summary judgment. I hate to do that because I think there probably is a fact issue. If I kind of delve through everything and did all the work that really, to be honest, you should have done. But I don't know that that's really fair to the plaintiffs for me to do that.
Well, Your Honor, if they're silent on the very first aspect to get to the very first issue.
How do you say that they're silent? It's briefed extensively. I don't know how you can say that.
There is nothing in their evidence that even establishes that there was a duty owed to the plaintiffs. Now,
can you see right here on the screen? It's page 9, paragraph 36. Combs has fiduciary duty to the plaintiff, and they've cited to all of this transcript where Mr. Combs testified, and they say he admitted that he owed a fiduciary duty.
If you were to look at it, it doesn't ever say that. It's an inferential leap.
Okay, but
if it's silent, Your Honor, they have to prove the case. If it's silent,
it's not silent. Okay. Ms. Farrell, do you agree?
I agree with you, Your Honor.
Your Honor, I normally do. I don't, respectfully so. I just think that if they cannot or show everything conclusively, that it must go forward. She even said that they can't prove damages. It
Well,
must go forward.
but I didn't say we couldn't prove damages. What I'm saying is that this is a modest, it's a modest motion, right? We're asking for partial summary judgment on one aspect of liability that I think is very clearly established and to which the movement did not respond. And, you know, Your Honor, with respect, I agree with you that, in fact, I don't even know that you're permitted to take into account the oral argument that is, or, you know, you're not permitted to hear new evidence now in the or argument that wasn't raised in the briefing that was offered by the non-movement. Even with respect to the question of gifts, I think if you scroll down to paragraph 40 something, 41 here, 41, a duty to account for and disclose gifts and ancillary benefits received. So part of the defense that has been raised by the defendant is that some of this money or assets were gifts. And that is part of the fiduciary duty, is to distinguish between what was gifts and what was not. And we are unable to do that. And that's, you know, one of the reasons why we brought this up, is because there have been allegations or inferences that some amounts may have been gifts, but we are unable to distinguish between them. And that is part of the fiduciary duty that is owed by the defendant and the non-movement, and is really not disputed by the non-movement's response to our motion.
All right, this is what I'm going to do. I'm going to go ahead and grant the interlocutory summary judgment. Mr. Galini, I will say this. I think that in all likelihood, if you had filed a response that had addressed their concerns, you could have raised a fact issue. I just don't think that what you filed did that. And so this is interlocutory. You can always move to reconsider if you want to kind of, I don't know, maybe you have, your client isn't able to pay you enough money to file, you know what I mean? Just sometimes you're constrained by the budget of the case, but what was submitted in response to this motion, I don't think raises an issue of material fact. I think they're, you know, in 80 to 90% of cases that I've had this issue come up, I usually deny them because usually there's a fact issue as to fiduciary duty, the existence and the breach of fiduciary duty. And just in this case, I don't think that the response raises a fact issue as to that. And so, anyway, I guess that's it for now. Ms. Farrell, did you submit a
proposed order?
Proposed order, yeah.
We did submit a proposed order, Your Honor, and part of that was asking for the payment of the $6,000 that we paid to the digital forensics people who are the what are they called? They're accountants, forensic accountants, to try to go through the records and figure out what funds had moved back and forth.
I'm not going to allow that. I'm going to grant it just on the issue of fiduciary duty.
Okay.
Let me see real quick. When did you submit the order?
It would have been probably concurrently with the motion, so something like way up from there, probably May 23rd.
Is that it? No.
Yeah. Wait, hold on. Yeah, probably that. The 24th.
No, that's this one here.
Yes.
Okay.
This is clever.
All right, I will go ahead and print that out, and then let me see. I don't know how to put this. I want to make it clear that I'm just granting it as the issue of fiduciary duty. You say there was some other request about money?
Well, I think that I put that in my prayer, but that it is not in the proposed order.
Okay. Mr. Galini, do you want me to include something in the order that says that it doesn't cover that?
Absolutely, Your Honor. And if you would place that it's interlocutory.
Yeah, it says partial, but I'll also put interlocutory.
Okay.
What did you say exactly? The payment does not grant move-ins. Was it, you said for forensic accounting fees?
Yeah, well, it was $6,000 for the forensic accountants that we'd requested in the prayer.
Okay, all righty. Thank you. Anything else, guys?
Your Honor, I do have one question about whether the court would entertain a joint motion to refer this case to further mediation. Not sua sponte, but if properly filed.
Absolutely. If you guys want to go to additional mediation, I'm perfectly okay with that. When are y'all set for trial?
July.
Oh,
Is it
wow.
September? Sorry. Yeah, I didn't
September,
move.
Your Honor.
Let me just look real quick and see.
And we have tried mediation. We're always open to it. Your Honor, last year, whenever we had our previous summary judgment, you had asked the families to get together in conference, and we tried to schedule that. And one of the two plaintiffs has still refused to do that, but everyone else has been on board in the family.
Have you been to a mediation already?
We have, Your Honor.
But it just didn't work.
Correct.
Once again, there's one holdout.
I mean, you're coming up on trial. My goal is to be trying cases once we start up. We're doing a rotation right now. I don't know if you guys are familiar with this, where every judge basically gets one date of jury trials. After that finishes up, then I hope, not 100% sure by any stretch, but that we'll start kind of going back to normal. And I anticipate once we go back to normal that we're going to kind of be nonstop. And so,
I hope you've enjoyed your break, Your Honor.
yeah, I know. It's going to be a rough time, but that's what they pay us the big bucks for. So anyway, all right, guys, great to see you.
Thank you. Thanks, Your Honor.
Thank you, Your Honor. Thank you.
Goodbye.
Okay. Did you guys all want different pictures? I can go ahead and order new pictures if you did.
That picture is better, the one that I sent you.
Okay. Oh, and guess who we saw, Alexa, at lunch today?
She already told me.
Okay.
Yeah, she was excited.